Welcome. My name is Caroline Stevenson, immigration attorney here in the United States. Now, today we're continuing with the subject of common lies that persons tell to get a visitor's visa that comes back to haunt them when they're applying for their green card. Now, one particular type of lie that quite a few persons have told to get a visitor's visa pertains to their marital status, right? And this time we're talking about a common law marriage. Now, a common law marriage is legally recognized even though it does not have the backing of a marriage license or an official ceremony. It is still legally recognized, and many persons apply for their visitor's visa and indicate on that visitor's visa application that they're in a common law marriage when they know fully well that they are not in a common law marriage. And once they have been granted that visitor's visa, it sometimes come back to haunt them when they're applying for their green card. Now, consider a particular scenario, this particular scenario. John Brown is a citizen, let's say he's a citizen of Jamaica. And in 2016, John Brown was in a relationship with Lisa, right? They never lived together, never had children together, but Lisa was his girlfriend, right? However, John Brown goes and apply for a visitor's visa. And on that visitor's visa application, he indicated that he's in a common law marriage with Lisa. And given that he's Jamaican, the presumption is that he would have been living with Lisa for at least 5 years for that relationship to constitute a common law marriage, that they would have been living together for at least 5 years, and essentially pooling their resources together as a couple and presenting themselves to the public as a couple. But John Brown goes to the embassy, he's interviewed, and he's granted that visitor's visa application. Now, he's granted that visitor's visa. Now, fast forward 10 years later, 2026, right? John Brown is now living in the United States. He's undocumented, but he's married to a U.S. citizen. And let's say the U.S. citizen is Mary Sue, right? Mary Sue decides that she wants to file for John Brown to get her green card, and she goes ahead and she files for John Brown to get the green card. John Brown and Mary Sue goes to their visitor's visa appointment. Bear in mind, this is 10 years later. John Brown completely forgets that he has a visitor's visa application that he had completed 10 years ago, in which he stated that he was in a common law marriage. So he's presently in the interview, and the interviewing officer, asks him, were you ever married before? John Brown says, no, I was never married before. The interviewing officer asks again, were you in a common law marriage before? John Brown, of course, does not remember anything about what was written on the previous application, and again, deny ever having been in a common law marriage. And at which point in time, the interviewing officer confronts John Brown and says, well, this application that you completed in 2016 to get your visitor's visas states that you were in a common law marriage. So how is it that you are now saying that you were never in a common law marriage? Of course, John Brown is, completely shocked, flabbergasted, and is, dumbfounded. He doesn't know how to respond, right? Because he's been caught in the act of lying, making a misrepresentation. At which point in time, the interviewing officer says to John Brown that, well, you are inadmissible, you are ineligible for this green card because of the misrepresentation or the arguably fraud that you have committed in 2016 when you applied for this visitor's visa. The interviewing officer proceeds to tell John Brown that, well, the only way for you to be issued or be granted this green card is for you to apply for a waiver or fraud waiver to overcome the fact of your misrepresentation that you did in 2016 when you applied for this visitor's visa. Of course, that now places John Brown and his wife Mary Sue in a dilemma whereby they are now going to have to scramble to present a case to U.S. Citizenship and Immigration Services to show that, well, John Brown's spouse will suffer extreme hardship if John Brown is denied the green card, right? That will involve a number of evidence. Usually it will involve medical records to show that Mary Sue is sick, and if John Brown is a primary caretaker for Mary Sue, that or those facts will tend to help John Brown in the presentation of his case to show that she will suffer extreme hardship if he is denied the green card. Right? So these are some of the factors that we have to consider when we are completing a visitor's visa application, because what is written on that application remains in your record and it definitely can come back to haunt you in the future. So be very, very mindful. Make sure that you are forthright and truthful with the information that you provide, because again, it can have extremely adverse consequences if you apply for an immigrant visa or a green card, right? So that is my 2 cents for today. I really hope that information was useful. Again, it is information that is intended for educational purposes and does not establish an attorney-client relationship. My name, Caroline Stevenson, immigration attorney here in the United States, and the number 347-451-4282. 347-451-4282. Thanks.